So when we say the child find process, that also extends to wards of the state, right? So individual students who may be in custody of the Department of Job and Family Services, um, and they might be in custody, as I mentioned, because they're in custody of juvenile facility. So know that a lot of times those students who are in the custody of juvenile facility, those students tend to fall through the cracks. And in 2014, there was a dear colleague letter, which is a letter that comes out from the U.S. Department of Education, where the where there was a lot of attention paid to those students who are incarcerated, and they wanted to clarify and make sure that schools understand that absent any specific exception, all of the IDEA procedures apply to students who are incarcerated as their parents. So, you can't just assume that a student who enters a jail or a juvenile justice facility is either not a student with a disability simply because they haven't been identified, just yet, and that you need to work with those who are most likely to come in contact with students in the juvenile justice facility, because you need to make sure you're dealing with your child find process, and that you have timely referrals, timelines met for evaluations. So, there in this guidance that was issued that said, absent a specific exception, here's the obligations for schools. Well, in Ohio, there is somewhat of a specific exception. If a student is within the custody of the Department of Youth Services, there may be some implications for who is the district of residence when for purposes of child find. So that district, so the Ohio Department of Youth Services has a school district. It's called the Buckeye United School District, and so that is where the district who is maintaining responsibility for child find is. However, a lot of people get this confused because sometimes students are not in DYS proper. They're in some sort of county program, some program that is operated locally. And those students, even if they are detained, those students continue to be the responsibility of the district of residence, and that is the district in which their parents reside. So those are individuals who are detained either in DYS or county. What about those students in private schools? So there are two different obligations. So a student who is attending a non-public school within the boundaries of your school district, you've got an evaluation responsibility for them. If you have a student who resides in your district, who might be attending somewhere else, that also could be the responsibility of you, because ultimately you might have to offer FAPE, right? So if they're located, they're identified, you might another district might do the evaluation, but you then might have to offer an IEP. So even if you think, oh no, the parent is going to a private school, you still may have a FAPE obligation to offer, because then they could say, well, I'm going to this private school because I didn't even know what you guys had available and what you were going to offer to my child. So those individuals. What about highly mobile children? What about migrant students? What about students who are homeschooled? What about students who might eventually attend your school program, like students who are in preschool? And then, as I mentioned, those students who are not in school because of truancy, hospitalization, drug treatment, social anxiety, some sort of reaction to bullying that they experience in the school. All of those students are those who tend to fall through the cracks from child find, as well as those students who are achieving academically, but also have some other types of needs that could be serviced or could lend themselves to IDEA eligibility. So I do have in your materials the Ohio law that talks about, what it constitutes the district of residence, the information from the U.S. Department of Education that talks about that, there may be child find obligations from two districts, because it's the district of the residence as well as the district in which the student is attending, because they might be attending a private school in another district. So know that there are dual obligations. There's dual obligations, and we'll get into this a little bit. If the parent disagrees with the evaluation that is done, There might be a dual obligation for an independent evaluation, just based on which district is conducting that assessment. So as I keep mentioning this idea about academic achievers, I just see that come up quite frequently when districts will say, well, when they come to school, they're doing fine, right? But they're not coming to school, and is the reason for that a disability, or when some issue about them not being able to do an evaluation because the student is meeting all of the expected academic standards. And just know that special education is there to address more than just a student's academic achievement. You're looking at functional skills, you're looking at all kinds of other things that may lend itself to eligibility. And we'll talk about that once we get into the eligibility determination. But again, if I had to pinpoint where I think child find hiccups occur, it's those students who are not in school for some reason, and students who are achieving academically but have some other issue. So, as I mentioned, you can't just sit on your hands, right? It's an affirmative duty. So you typically are going to be engaged in child find because of some sort of referral by the parent or a referral by an educator. And that usually happens when there's some sort of academic, social, emotional, or behavioral struggle that prompts somebody to suspect a disability. But because we have this affirmative obligation, you can't just rely solely on the parents to refer a student. So that's something that you guys would need to think about internally, of how do you process those referrals? How do you generate information so that you can ultimately determine whether or not a student meets the eligibility criteria? They might not. And that might be a perfectly appropriate decision to make, but you want to make sure that you've actually engaged in the child find process. Because what I see is child find violations are extremely expensive for districts. Why is that? Because when districts have to defend themselves in litigation, they usually are saying, look at this program that I offered. This is an appropriate program to meet the student's needs. However, if you've never offered a program because you never engaged in child find and you never determined whether or not the child was a student with a disability, you don't have anything to defend. So, and if you wanted to defend, well, we didn't suspect a disability, the best defense of the student not being disabled is an evaluation, not just saying we're not going to test because we don't suspect a disability. So just know that if you've got a student who's struggling grade-wise, struggling with social interaction, struggling with attendance, and there's some mention or some suspicion of an impairment that is leading to that, that is your best bet is to evaluate. That I was presenting in, where was I last week? And I was presenting in Alabama last week, and one of the others who were presenting said, when there's debate, evaluate. And I thought that was great, so there's another rhyme. So it is great that when there's debate, you evaluate, just do it. And I know you're like, well, we don't have enough school psychs. We don't have enough people to do these evaluations. We can't just, tie everybody up. Agreed, no doubt about it, there is a shortage of people. But if you're having a debate about whether or not a student is not progressing because of a disability, the best way to settle that debate is to conduct an evaluation. So, word to the wise. Okay, here we've got a question, and I can't see it unless if a doctor or parent, if a doctor or other person, not a teacher or parent, makes a request, is the district required to determine if we suspect a disability? We debate that often. That is exactly the presentation that I gave in Alabama last week, which was what happens when there is a prescription for special education? What happens when the doctor says student needs an aid or student is eligible? Again, they're not making that out of the blue. I think they're getting something from the parent. There's some concern. And so to me, it is important to, just like you have the responsibility to consider everything, to conduct an evaluation. Because, and my talk last week was really about what is the difference between a diagnosis under the DSM and a disability, because a lot of the diagnoses aren't related to whether or not the student requires specialized instruction. And as we go through this today, you will see that just having a diagnosis does not equal having a disability. Mindy's asking if we have students who are receiving behavioral health services in a partial hospitalization program, is that a trigger to meet to discuss the suspected disability? Is there a length of stay to be considered? Fun fact, and then, just because I learned this last week because I was presenting in another state. The state of Alabama actually has a guidance document that says when a school is on notice that a student has been has a diagnosis. It's kind of like a diagnosis plus, has a diagnosis, is hospitalized, like all of these things. It basically, they say, yes, school, you are on notice and you should be thinking about you should be triggering your child finder obligation. For us in Ohio, we don't have that guidance, but I would say that if a student is receiving behavioral health services in a partial hospitalization program, that tells me that the student isn't attending school because of a mental health condition. And, just because they do well on whatever reduced assignments or they are given extended time, the question becomes, do they require specialized instruction? So Mindy's question is, is that a trigger to meet to discuss? I would say yes. I would say once we know that the student isn't coming to school because of a health condition, you've got to see it. There's a diagnosis there, they're in a partial hospitalization program, and now the question is it a disability? And that's what we're going to be talking about for the majority of today. When is it actually a disability? Because that's that's a legal term, and that we have to provide some sort of services for. What about, to take Mindy's question one step further, what if the student has been hospitalized in another state? That also becomes quite expensive when you're thinking about, well, we have never evaluated a student, and suddenly you're getting a bill from a school in another state because the student has been placed there because of their mental health issues. Again, becomes very difficult to defend that, because if the student is that it's that severe, where we're talking about residential placement, the question becomes, what was the information that was given to the school? And if the information was nothing, like if the information was the student was coming to school every day, there was no issues, there was no behavioral issues, there was no performance issues, there was no issues of social interaction, and maybe it's just something that was occurring in the home, that might be easier to defend. But ultimately, once you get that notice, it's important to go through the child find process, and think about, I think on the next slide is, what is a referral? Like, what I think that's the next slide. We'll see. Is a referral? What are the things that you need to do? So, know what isn't a referral and how to, and don't ignore them. So, we are required to do response to intervention. You're required to provide interventions to resolve concerns for students. Well, what happens when they are not responding to those interventions? So, know that there is no requirement that a referral be in writing or have some sort of magic words. Somebody might say, I think my child might need help. I think my child, as they're testing, that could be a referral. And so that could happen at a parent teacher conference. That could happen with, the aide that brings the kid to the pickup line and gets the child in the car. And maybe that's the only person that the parent talks to every day. So know that, when you're thinking about your referral responsibilities, it is a lot more than just, I want special ed. It doesn't have to be just that. So but it has to be more than just you. Like, your principals need to know that, your teachers need to know that. And because remember what I said earlier, the child find obligation is an affirmative one. So the parent can initiate a request. But once there is a referral, the district is responsible for doing something within 30 calendar days. Okay. That is the very distinct timeline. And so if that nobody knows that the referral has been made, then nobody is processing the referral within 30 days. So the referral, what has to happen within 30 days? You have to do one of two things. Number one, you have to get consent to proceed with evaluation. Okay. Number two, you have to say to the parent, we don't suspect a disability. Okay. We don't suspect a disability. So this highlights the fact that because you have two options within 30 days, it highlights the fact that you don't have to evaluate every student when there's a referral. So every request for an evaluation does not automatically trigger an obligation to evaluate. Districts can refuse if they don't suspect a disability. But here's my caution. If you do refuse, understand, and this is in your materials, and this is something we will talk about in the discipline session that we have in a couple, maybe in January. But know that when you refuse to evaluate, okay, when you say we are not going to evaluate, the student continues to be suspected disabled and entitled to the same disciplinary protections as if they were disabled. More on that in an upcoming session. But there are, there's no way for you to, well, the only way for you to, when their referral has been made, to close the door on special ed discipline protections is to actually conduct an evaluation and determine that the child is not eligible. Okay, yes, here is our referral. So those are their two options, and either obtain informed consent from the parent or issue prior written notice explaining that, we don't suspect a disability. Now, when there is a referral, okay, that starts your timeline running. That starts your process for, engaging in your evaluation. So you have a requirement that that you conduct the evaluation and complete it within 60 calendar days, not 60 days when the school is in session. 60 calendar days. If you get a referral on May 31st, and you get consent from the parent to conduct, and you determine you're going to conduct an evaluation, you get consent from the parent, that evaluation has to be completed and done over the summer, even if you don't have a school psych who is on a contract over the summer. So you can't say to the parent, oh, you know what? We got this. Everybody thinks we should look into this, but we want to implement some interventions before we even do an evaluation. That's a no-no. You can implement the interventions while you are going through your 60-day evaluation process. And at the end of those 60 days, you can look at a student's response to those interventions, but you cannot put off an evaluation because you have to, because you want to do these interventions. All right. Now, know that here's an update to the operating standards. There's a revisions in the operating standards included a clarification that the timeline to complete an evaluation is 60 calendar days. Now, that was how, I don't know, we all read it before, but anyway, it's there in black and white. It's 60 calendar days. If you are having to complete an evaluation during the summer, how would you suggest conducting an observation since the student would not be in session in school? And so to that point, you are determining if an observation is required. Okay, so the team is, or when you're developing that plan, the question is an observation actually even required? And the team can determine that it's not required. If it is required, you can certainly tap into the observations, anecdotal observations from teachers who've had that student in the past. Okay, when does the 60-day start? After you accept the referral? No, the 60 days start when the district receives, well, the 60 days starts when the district receives consent to conduct the evaluation. So if the parent, you give the consent form, because remember, you've got a 30-day period when you receive the referral to either obtain consent or say you're not going to test. And so here's your consent. Now look on this thing, it says, I'm giving consent and, I give my permission and the date of that. Well, let's say the parent dates that what's today's date? Oh, it's Friday the 13th. So they date that Friday, October 13th, but they don't send it to the district until October 31st. So what is the date? The date is not the date of consent. The date is the date that the district receives it. Well, what if the district receives it on October 31st, but it sits on the principal's desk and it doesn't get to the special ed director until um, until November 5th. So what is the date? Not the date. The date is the day that it came into the district, which is October 31st. And the question now is, do you even have a way to date that? Is somebody stamping it received by the district? If nobody knows what day it got to the district, guess what date ODE is going to say that it starts on? October 13th, the day that the parent signed it. So, think about, you should have some sort of system so that people know when we receive these consents for an evaluation, excuse me, because that starts the timeline. It's not the date that it was signed. It's not the date that you got it because you are the special ed, supervisor. It is the date that the district received it. So you need to have some way to know what date was that and be able to document it. But
And if
people
I can pop in here real quick,
Yep.
Laura, that kind of prompted my question about the observations. OEC just did a webinar and said that observations were required for all initial evaluations last week. So that came from the Office of Exceptional Children. I'm gonna venture a guess some of the people were on that same call. And I think that's where that confusion of, can you choose to not have an observation on that evaluation
Well,
planning?
I'm glad that they said that, but I'd like to know what the legal authority is for that, because I don't believe that the operating standards require for an initial evaluation to have a, I know they said it, and I believe that you said it, but the question is there a legal requirement for that? And my response to ODE on those things is it a legal requirement, or are you talking about a best practice? You've heard it here from me. Where is the legal authority for that? And you might need it. I mean, I'm just suggesting it might be something that people need. All right, consent. This is another thing that trips people up. So consent is not just agreement. Consent is a very specific legal term. Okay, consent means, and in the IDEA, there are several places where the word is used agreement or the word is used consent. And that is done deliberately. Consent is not agreement. Agreement is not consent. What consent is something that is legally required. And if you don't get it, you can't go forward. You cannot pass go on the, Monopoly game or whatever. You can't move forward if you don't get consent. But you only need consent on very, very few situations. Okay. And those situations is when you have to get consent. And there are 3 requirements for consent. Number 1, that consent be informed. So the consent being informed is that the parent is fully informed of all of the information relevant to whatever you're asking for consent to do. So, and to be fully informed, you have to be fully informed in your native language or through another mode of communication. So when you're asking, and let's just take it in the context of an evaluation, when you're asking for consent to evaluate, you have to be fully inform the parent of all of the information relevant to that evaluation. What areas are we going to assess? Who's going to do it? What is and if there's questions about what assessments are being conducted, that's getting informed consent. Okay, so that's one piece of the puzzle. Number 2, to get informed to get consent, the parent has to understand and agree in writing to do that activity. And the consent then describes the activity and lists, what's going to happen. If you're getting consent to release records, identify what records are going to be released. And then the final thing when you're getting, legal consent is that they have to understand that the granting of consent is voluntary and may be revoked at any time. And so if you look at this the PRO5 document, you will see that there's language in there that says, "I understand the granting of consent is voluntary." That is what needs to happen when you're getting consent. So, you have to use a document that shows that you've gotten proper legal consent, which means that a parent sending an email or a text to somebody that says, "Go ahead and evaluate," is not legal consent. Or the parent on a phone call saying verbally, "Yes, consent, go ahead, do that observation test." That's not going to fly. They may be able to agree to something, but you can't agree to conduct an evaluation. Okay, you actually need consent for an initial evaluation, a reevaluation with new assessments, a change of placement in Ohio, not in every state, but in Ohio, and release of records. Those are the times that you need consent. You do not need consent when you're doing a new IEP that it doesn't change placement, when you're doing an annual review. I'm sorry, and there's one more, the initial provision of services. So the brand new first time IEP, you need consent to implement services. That's it. So if you are making some adjustments to the IEP, you write new goals, you're going through an annual review, there's no change of placement, you do not need consent. You don't even need agreement. Okay. And so many districts get really hung up on being paralyzed when they don't have something in some sort of signature. The only time you need that signature is when you are required to obtain legal consent. What happens when the parent won't consent to the evaluation, but the district suspects a disability? So, if the parent is seeking, um, well, if the district is saying, we really think there's something going on here, we've asked to try to evaluate that student. The parent will not allow for it. There is the option for the district to file a due process hearing to obtain an evaluation over the parent's objection. Okay, so that you can use the procedural safeguards as an option to try to force the issue. The problem with that, well, number one, it's a good process to show, listen, we were trying, not legally required, but you're trying, show that um, you were trying to address concerns. The problem is, even if the hearing officer gives you the ability to evaluate, and even if the evaluation is conducted and the student is determined eligible, the thing that you cannot do through due process or through mediation is force special education. So, you can do this process so that you can bulletproof yourself later when the parent is like, well, you should have known better. You should have forced this issue. And now my child is in 10th grade and can't read. And you're like, we tried. And we actually even tried to do this through this process. What about conditional consent? What about when the parent says, well, I will only give you consent if if my child is tested by this person at the Cleveland Clinic, or the assessment is only done while I'm in the room sitting 2 feet away from them, or that you're only using this instrument. There's a lot of legal authority out there that any type of conditional consent is not consent, and that the district does have broad discretion to conduct an evaluation without being kind of they have their hands tied behind their back on those conditions. And the reason that there's broad discretion afforded to schools to develop the plan and you know, identify what areas needs to be assessed is that there's a procedural safeguard that is given to the parent that if they disagree with that evaluation that the district conducted, the remedy for them is to request an independent evaluation. So more on that. We'll talk about that in our procedural safeguards session. But that's, when you're thinking about consent, for evaluations, a lot of times people are given all these conditions. So we are going to be talking a ton more about consent under the IDEA in our session on procedural safeguards. So, but just know that there's more to that. So let's get back to our evaluation. So lots of different things have to happen. So the important paperwork is our prior written notice that would also accompany the information about what evaluation is planned. You have to identify what procedures you're going to use and what tests, what areas you're going to assess. And then you're going to need your consent for an evaluation. You're going to need the whatever it's called someday when we see this new formally known document as the whose idea and guidebook, whatever it's called. I think it's going to be called a roadmap. I think anybody who has intel on that, I feel like that's the floating title, but that will be something that you're going to need to send, and then you're going to need to have some sort of invitation because you're going to be having a meeting. Who's going to be on that team when you're having a meeting? I think that's my next slide. This is the evaluation team is defined as parents and a group of qualified professionals. So you're going to have at least, one regular ed teacher of the child, at least one special ed teacher. So these are your IEP teams. So, how do you deal with this in an evaluation when the student's not eligible? You're doing the best you can. So others, you're going to need to have a district rep. You're going to need to have, maybe others who have specialized knowledge or expertise. So you're just really looking at those individuals. The person who's very important in this process is somebody who is, number one, the district rep. That district rep, and I know that for some evaluation team meetings, districts are using school psychs as the district rep. Just know that the district rep definition of who can serve as the district rep is very specific. So a district rep is somebody who is qualified to provide or supervise the provision of specially designed instruction, so either to deliver or supervise, is knowledgeable about the general ed curriculum, is knowledgeable about the availability of resources in the public school, and really is somebody who can make the call on behalf of the school. And then the other important person is an individual who can interpret the instructional implications of the evaluation result. So that could be the school psych, but it might be somebody else if you have evaluation results in other areas. All right. There's some special rules, and I think that's this on my next slide. Yeah. So there's some in your materials. There's some special rules regarding specific learning disabilities. I'm not going to cover specific disability categories just in the interest of time, but know that for your initial evaluation, we talked about this. You've got 60 calendar days. Know that you have to do it. It has to be comprehensive. You can't just have a single source to meet the criteria for determining eligibility. You have to use a variety of tools and assessments. So make sure that you know how to calculate your 60 days. What happens if the 60-day timeline falls on a weekend or holiday or school closure? If that happens, then you want to have the ETR completed on the day before the weekend or the holiday. Just, word to the wise, like, don't schedule the meeting on the 60th day. Make sure you know when the 60-day timeline begins, because you have a system to identify when it got to the district, and know when you really want to have the process brought to closure. A question: is there an updated revision to the procedural safeguards, or is the 2017 document the most recent? They are in the process of revising it. They don't have it done yet. I know I had a meeting last week with ODE representatives, and I know that it has gone through several iterations. And so it is in process. I can't remember. I think the name is called Roadmap or something. Initial evaluations. Know that a note that who conducts the evaluation has to at least be somebody who's qualified to conduct individual diagnostic examinations of children. So think about is there somebody on the team who, beyond the school psychologist, I mean, maybe there are additional assessments that could be done by somebody, somebody who's a reading specialist, things like that. I mean, I'm trying to give you ways to free up the people who I know are really hard to, who are overloaded at this point. So lots of different requirements. in addition to not having a single source, you need to make sure that you're, when you're doing assessments, that they're done consistent with the way that the assessment is intended. You're using technically sound instruments. The assessments that you're using are administered so that they're not discriminatory in nature or, impacted by any type of cultural, racial bias. Making sure that you're dealing with and contemplating, what you might need to do differently if a student is English with second language. Are the assessments provided and administered in the child's native language or other form of communication? Is the person who's administering them trained and knowledgeable? All of those things. You're making sure that you're assessing the actual disability. So if the child has some sort of impaired sensory or impaired speaking skills, making sure that you're actually assessing the disability versus some sort of impact from sensory issues or language, expressive language issues. So, and you have to make sure that it's comprehensive. So looking at all areas of suspected disability, including health or vision or hearing or emotional status or communicative status, motor abilities. Curtis asked, can a school psych be the district rep at a planning meeting? Know that a planning of an evaluation does not have to be a full team. There's no legal requirement to convene a team meeting to do planning. So I think that the school psych can be the person who's assisting with the planning of that. But that was operating standard, the last revision of the operating standards. We don't have that. If a parent states they have academic or behavioral concerns, but don't expressly request a special ed evaluation, can we suggest the RTI tier 2 interventions first and use that data towards possible special ed evaluation? Well, the question is there a suspicion of a disability? Nobody has to give magic words or magic language, right? They don't have to say, I want a special ed evaluation. So ultimately, the decision is, is this a referral? Do we suspect a disability? Because remember, you can do one of two things. You can say, we don't suspect a disability. We don't suspect a disability, and we are using those 30 days to look at different things. And we don't suspect a disability. We're not going to do an evaluation. You can say that, and then you can do your interventions. But you can't once you suspect that there's a disability, you can't say, well, we're going to do interventions instead of an evaluation. Again, you can do your interventions during the time that you're processing an evaluation. And then you can say, as you're doing that, oh yeah, look, the student responded to these regular ed interventions. So therefore they don't need specialized instruction. We're going to talk about that after our break, but you can make the call and use that data for your eligibility determination. So who needs to be at a planning meeting? Who needs to be included in a planning meeting? So can the school psych sign as district rep? As I mentioned, there is no requirement to have a meeting to do planning. Now, if you decide you want to have one, invite whoever you want, okay? But there is no legal requirement to have a plan to conduct an evaluation through a team meeting. Okay, I'm looking. I know people do that because that used to be how it was. All members are not required at a planning meeting for an initial. All members are not required at a planning meeting for an initial evaluation. I think that was meant to be a question, and I don't believe so. I can look that up in the break. I have my operating standards right here. All right, I'm going to move on. All right, so when you are conducting an evaluation, let's go back to that slide, Maya. When you're conducting an evaluation, you are doing two things, whether it's an initial evaluation or whether it's a reevaluation. You're doing two things. You're asking the question, is this a child with a disability? That is a legal term. A disability is a legal term. Yes or no? Okay, if you answer the question, yes, it is a child with a disability, then what are the student's educational needs? Okay, so when you're asking that question, is this a child with a disability? You could answer, the child might currently be disabled, But what we're going to talk about after the break, and we're going to use my three-legged stool analysis, is that you might have a child who was disabled pursuant to that definition, and they are now no longer require specialized instruction, which is one of the requirements. So you can make that call and say, no, this is no longer a child with a disability, because even though they have a diagnosis, okay, even though they have something going on, they don't have an adverse effect on their education, or they don't require an they don't require specialized instruction. All right, and to the question that came up about what is required for an initial evaluation, your written materials has all of the information in there about what's legally required. And I know that there's some chatter about what ODE is going to do with respect to monitoring and things like that. I can tell you that I know some districts have had um, different experiences with monitoring, and so I can never predict what ODE is going to say within the context of their monitoring. Sometimes the things that they say are required are not legally required, and so if you want to make your decisions based on what ODE it does in monitoring, that's perfectly appropriate. But me, as I mentioned, what my bias is, I am an attorney that works with school districts, and I'm interpreting what the operating standards say, and so putting my bias out there. All right, what is our next slide? All right, so I mentioned this. So if you have a student, you have to look at all areas of suspected disability. If a student, if there's some sort of medical issue going on, you as the district are responsible for evaluating that. So you can consult with those treating, medical providers. But if the school thinks that there is some sort of requirement for, you need to have a diagnosis of such and such before we will consider this and that. Know that you can't just say, okay, go get a diagnosis. The district is responsible for evaluating in all areas of suspected disability. So if you think a medical is required, legally, again, my bias, this is where I'm coming from. Legally, the district's required to do that. Okay, to consult with a medical provider to obtain a medical evaluation. All right, moving on. What is our next slide? So here's your plan. So when do you have to do this? You have to do it at least once every 3 years. You have to look at your existing evaluation data. You have to identify if there's anything else that is necessary. You don't have to do it more than once a year unless there's some sort of agreement. Okay. So, know that your reevaluations, your evaluations need to look at this standard. There's some new information. There is in the revised operating standards about transfer students. This is in your materials. The child transfers from another Ohio school district. The new school district has 30 days to either accept the evaluation conducted by the prior school district or obtain consent. So that 30-day timeline starts on the day that the receiving school district receives the evaluation from the prior school district. And then any reevaluation has to be completed within 60 days of parental consent. Question, can you please repeat the information on medical consult? What was legally required? So if the IEP team, if the evaluation team thinks that you need to have a diagnosis or some sort of medical information, if the student, you can't just say to the parent, hey, go get a diagnosis. The district is required to evaluate, legally required to evaluate in all areas of suspected disability. So once the team says a medical evaluation or a medical diagnosis is required, it is the school district's obligation to conduct that evaluation. Now you can conduct that by hiring your own doctor. Most of the time, parents are not going to send the kid to a doctor that the district proposed, but just know that you can't just shift the burden to the parent to go get that medical. Okay. Your materials have separated out new the initial evaluations and reevaluations. So when you're getting consent for a reevaluation, sometimes you don't get a response. Sometimes the parent is going to not send in the rating assessments that you provide. Maybe they're not going to, there's some sort of block where they're not participating. Know that for a reevaluation, if the parent fails to respond after you've made reasonable attempts, you may be able to proceed with a reevaluation. So there are some, and this is all strategy that if you're getting into the situation where you really do want to, do more things and you're not getting a response. That's not the same as getting the response of no. That is a response. Might not be a response you like, but that is a response. So if there's a failure to respond, my suggestion would be to consult with your legal counsel about what you might want to do moving forward, because you have some options. What is required for reevaluations in terms of homeschooled students? Okay. Homeschooling is like any other non-public situation, students that attending a non-public school. You still have to propose to reevaluate. You still have to propose an initial evaluation if the student is your responsibility for purposes of child find. So you can't take this out of sight, out of mind. These kids are homeschooled. I don't have to do anything. That 3-year reevaluation obligation is still required. Okay. And, if the student is determined eligible, then you'd want to propose an IEP. The parent can reject it. Now, if the parent states their unequivocal intention not to enroll in the student, then you would make sure that then I would have that in writing. And then you would, send out a notice saying we're not going to propose an IEP next year, but I would still go forward and try to conduct reevaluations. Do we have to do the IEP each year, even if not monitored? As I mentioned, proposing an IEP is what I would do unless you have some written determination from the parent written confirmation from the parent that states, I don't like your district. I don't want to be in your district. I'm never going to send my kid to your district. Make sure that you are uh, responding to the responding to that. But if you don't have that, then I would be proposing an evaluation. So I know there's been some chatter about consent for any new assessments. And the answer to that is that's not a change. That is, as I mentioned, you need consent in order to do new assessments, right? So that is something that has been in the IDEA under the consent provision. So just confirming that it has been a requirement. So what if you decide that no additional data is necessary to determine continuing eligibility? So you're going to have to make sure that you notify the parent of your determination. We don't have to do any more assessments. This is really where you're giving them, all of the information. You're giving them visibility on your process, and you can determine that you don't need anything else. All right, next slide. Which is our three-legged stool. Okay, and we are right at 10 o'clock, we are 100% on schedule. So what we are going to preview when we come back from the break is we are going to preview this idea of IDEA eligibility. And this is my not so, artistically rendered, or probably this three-legged stool wouldn't even stand, but this is my graphic to give you this imagery of a three-legged stool, because you have to have all 3 legs of the three-legged stool in order to meet eligibility under the IDEA. In order to have an IEP, your team has had to have found all 3 of these things: disabling condition, an adverse effect on educational performance, and the need for specialized instruction. Okay. If you don't have one of them, student is not eligible under the IDEA. And so when we return from the break, we're going to go through disabling condition, adverse effect, and need for specialized instruction, so that you guys understand when you're going through your evaluation process, how do you get this determination right with all of the bells and whistles and the stuff that you need to consider. Because it's not the same, when you get that prescription from the doctor that says student has X, that might be a diagnosis, but that doesn't lend itself to knowing, is it a disabling condition? Is there an adverse effect on educational performance? And does the child require specialized instruction? When you have 2 districts that are responsible for child find, know that there's 2 different responsibilities. The district in which the private school is located, if the student is found eligible, might be required to develop a service plan for that student based on how that school and the district in which the private school is located have negotiated the expenditure of federal funds for those students. So, for example, my last name is Anthony. If Anthony's school of, um, let's see, Anthony's school is located in, you know, IDEA school district. I'm just giving, yeah. Anthony's school is located in this school district. I'm a private school. Me and the private school and the school district, in which the private school is located, will go through this process of consultation because there's federal dollars that are generated for all of the students who go to Anthony's school who may be entitled to special education services. So, it could be that they have one kid with a disability and there's maybe, I don't know, $1,000 generated for that one kid. Well, maybe the Anthony school and the public school have decided we're going to spend that $1,000 on a speech therapist. I know you can't get $1,000 of speech therapy, but whatever. We're going to spend it on speech therapy. Well, let's say that the little Laura is going to Anthony's school. She is sitting, so she gets evaluated because the school district has to evaluate students who attend Anthony's school for suspected disability. And we find out that little Laura has a hearing impairment. I'm trying to think of something. Has a math disability. I have a math disability, and it's math calculation. And so I would go back to Anthony's school and we'd say, okay, well, this is math calculation. And Anthony's school said, well, what we're using the dollars for is speech therapy, and you don't qualify for speech therapy. So the student doesn't get a service plan because those services would not be provided pursuant to that interaction between the school district and Anthony's school. But little Laura then can go to her school district of residence, the school district in which she resides, and she can say, either take this evaluation that the school district did, the school district in which Anthony's school is located, take this evaluation, and I would like you to offer me, a FAPE. And so the school district that is the district of residence, they are responsible for writing an IEP. The school district in which the private school is located is not required to offer FAPE. They are only required to implement a service plan based on what services are provided. So two different kinds of obligations, two different school districts that have responsibility, but they are not the same. So if little Laura decides to stay at Anthony's school, she may not get math, specially designed instruction in math. And that is a choice that they make. But they have to be able to go to their public school district and have that public school district say, if you were to enroll here, this is what we would deliver for you. You need consent before conducting any new assessments. That is what I said. Consent is required when you are initial evaluation, reevaluation with new assessments, initial provision of services, change of placement in Ohio, and release of records. So that consent is required to conduct new assessments, and has been. All right, we're getting to our three-legged stool. So why do we try to get this fundamental correctly? Well, number one, you have to get your eligibility decision right. You have to make sure you make that call in the right way. And a lot of districts, they feel somewhat caught in the middle. They have families who believe that they need some sort of designation of special ed, identification in order to receive appropriate services. You've got educators who may be general educators who are saying, listen, this is the way I teach. And if somebody else needs a different method of delivery of a services, they need to be in special ed. They must be identified special ed in order to get something different. And then sometimes you have administration who says, listen, it's just easier. It's easier to identify the student than to just be in this conflict with the parent. And then you've got your state and your federal agencies that say, listen, schools, you cannot stop over identifying people. Stop over identifying students with disabilities. So you've got all of these navigating and competing interests. And so districts have to understand the fundamentals of the eligibility process in order to be legally compliant. So before we get into the cases, you should know that once, if there's some court decision or some court litigation, courts typically focus on these three central factors, and they base their eligibility determinations on how these factors are determined, how they're evaluated, and how they intersect with each other. Now, if you were about to sit down at your favorite, family event, and they are giving you stools, you got a picnic table and you got stools, and you've got, you know, two of the three legs, what is going to happen? You're going to fall down. If you have one leg that is like super short and not really, all that reliable, you might also fall down. So when you have one leg that is emphasized at the expense of the other, we don't have balance and you don't have a solid foundation. And that's the same as when you're doing your eligibility determination. So just remember this, that you have to have all three elements in order to have a balanced stool. So, and in it, you might say, okay, well, yeah, this makes a lot of sense. Disability, adverse effect, and need for specialized instructions. I will tell you that it's not as clear cut. Okay, so educators and teams and hearing officers and courts sometimes are divided in how to apply these terms and what constitutes educational performance, what constitutes adverse effect, what constitutes a need for specialized instruction. And that's where we get into a lot of the debate and the debate in the decisions. So the first one, we'll start. I think I have a question. The first one is child with a disability. Okay, so that's your disabling condition. But let me see if I have a question. Oh, no, not a question. Okay, so child with a disability. This is easy, right? You have somebody who meets the criteria for one of these disabling conditions, and the disabling conditions list is exhaustive. Okay, so, and know that there was a change. The change is intellectual disability. So that change came through our operating standard. So we're using that phrase now. And so it is somebody who has been evaluated in accordance with the IDEA as having one of these things. So we've got your hearing impairments, intellectual disability, speech language, visual impairments, emotional disturbance, orthopedic, autism, traumatic brain injury, other health impairments, specific learning disability, deaf blindness, multiple disabilities. And so all of these are your things. And so there's this list, right, of, well, who is a child with a disability? Well, at the end of that list, it says, okay, listing all these things, and who by reason thereof needs special education and related service. So it's not just that I have autism, although that's, from the budget bill, we got some new stuff there. Let's take it from, it's not that I have a hearing impairment. Okay, because you might have a hearing impairment and you don't require special education or related services. Could happen. Okay. In order to be IDEA eligible, it is not just that they have this condition. This is just the first leg of the three-legged stool, because you also need adverse effect and you also need the need for specialized instruction. The 2023 operating standards also include a new definition for other health impairment. So know that we've got other health impairment major. So that is a child who has identified as having a medical condition among those listed, or the child is determined to be a medically fragile child. And then you have other health impairment minor, a child who meets the definition of other health major but doesn't meet that major. So it's the medical condition and or medically fragile, or everybody else. So it's really important that those eligibility determinations that you make are based on standards that are set forth in the IDEA. And so the first step in making these sound decisions is to review the definitions every time you consider a student's eligibility. Okay. I have a copy, it's actually downstairs, I should have gotten it. I have a copy of the Diagnostic Statistical Manual for Mental Health Disorders. I like to use that because I like to know what is the difference between the DSM, because that's what the doctor is using, and what is required under the operating standards under the definition of a child with a disability. So, think about that when you are looking at it. Now, you know, until this summer, you could say, let's say for the autism, right? So autism, in order for that to meet eligibility criteria, you have to have a developmental disability, this is under IDEA, that significantly affects verbal and nonverbal communication and social communication that adversely affects the child's educational performance. That's your IDEA definition. Okay. The IDEA definition also contains rule outs. Basically, autism doesn't apply if the child's educational performance is adversely affected primarily because of an emotional disturbance. So you have to then go over to the emotional disturbance definition and say, is that what we're seeing here? And you've got to go through all of those criteria for emotional disturbance, okay, and rule that out. Well, but if you look in the DSM, how a student might be identified as a student under autism disorder, it doesn't have those things. I mean, it's not in alignment. Okay. And so that becomes a conversation point at almost every ETR meeting, because it's really critically important that parents and educators and doctors, district reps, all understand that the eligibility determination is based on the IDEA definition and data, and not on a medical diagnosis. Okay, just because a student is diagnosed with depression does not mean that the student meets the criteria for an emotional disturbance under the IDEA. The diagnosis and disability start with the same letter, but they are not the same thing. And unless you go through your analysis, you're not going to be able, and if you just take this prescription that says child has depression, therefore they are eligible, that is not true. So don't think that that's the approach that you should take. Having a diagnosis may create a child find issue, but it doesn't answer the question about eligibility. Okay. Hopefully that's clear. Not all children with diagnoses are IDEA eligible, because remember, we need all three legs of the three-legged stool. Some children that have diagnoses that don't require specialized instruction might be eligible for protections under Section 504. Okay, might be. Again, there is an evaluation requirement under that. We will have a separate full session on Section 504, so sign up for that if you want to dig deeper in there. But for purposes of the IDEA, it is only those children who are currently and educationally disabled who are protected by the IDEA. Okay. It's not, I have this diagnosis and sometime in the future, I have this degenerative hearing issue, and sometime in the future, it is going to impact my hearing. Well, that is not a student who is disabled, who has a disabling condition that has an adverse effect right now on our education performance, and right now requires specialized instruction. They have to be currently impacted by this disabling condition, and they have to require specialized instruction. So again, we're looking at all three legs of the three-legged stool. All right. I have in your materials tons and tons of cases about eligibility, cases about where courts and hearing officers were debating, does this student have a disabling condition? So this is the section we're talking about here. And again, courts are saying a child who is at risk of having a disability in the future is not considered a child with a disability. And then we've got, genetic disorders, or that you want special ed services as a preventative measure. No, it's really looking at right now. There's an interesting case in your materials called Marshall. It addressed this issue about potential adverse effect, but it also had some good language in there that reinforces the point about the interplay between a medical diagnosis and eligibility. And there was a quote from there where it says, that a physician's diagnosis and input on a child's medical condition is important, and it bears upon the team's informed decision on student needs, but a physician can't simply prescribe special education. Just say that again. A physician cannot simply prescribe special education. Rather, the IDEA requires a full review by a team that is composed of parents, teachers, special ed teachers, regular ed teachers, district rep, and that is a process that is not a medical diagnosis. So again, please, 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 if you get something from the physician, or from the physician through the parent, or from the therapist, or from the private speech therapist, or speech, anybody, your response should be, thank you so much for sharing this information. We think that that's, really good information for context for the team to consider. Here is a release. Need your consent. Here's a release for us to talk to this person who made this diagnosis or gave this recommendation or said the child should have an aid or said they needed speech therapy, whatever it is. We'd love to get some more information so that our team can understand the recommendations here, and so we can bring it to a full team's decision, because in our process, in the education world, these decisions are made by a team. So we'd love to get more than just this one sentence on this prescription pad so that we can fully consider it. So always ask for that when you get outside individuals recommending educational supports. Now we're talking about educational performance. So the next leg of the three-legged stool is, what type of educational performance do we have to consider? So the IDEA does not define what educational performance means, but we know from the case law that educational performance does not exclusively mean academics. It does extend beyond grades, beyond standardized test scores, and into other areas such as, behavior, emotional regulation, emotional development, interpersonal skills, things like that. So if you've got a student who can't form social relationships, or cannot attend school regularly, or cannot control their behavior, and so they're excluded from school, but they do well academically, you may have an impact on educational performance, and you cannot just look at grades and assessment scores when looking at educational performance. And how do we know this? Well, think about, what is the purpose of the IDEA? Purpose of the IDEA is to prepare students for further education, employment, and independent living. That is well beyond academics. You're teaching them skills so that they can be successful in their post-secondary goals. So, lots of cases in your materials in which it's looking at this issue as, what is academic performance? So if maybe you have a student who appears to have no issues at school, their grades and attendance are fine, the behavior is fine, the social skills are fine, but they are having significant problems outside of school. They're maybe involved criminally, or they're having a lot of conflict in the home setting. Maybe there's violence in the home. Maybe there's student is running, like, all kinds of things that are happening, but at school, they are doing fine. I've actually litigated cases like this. And, some hearing officers will say, if the student is not having an educational impact, then, it may be a student who's really has a good ability to compartmentalize. But, if they're not having an educational impact, then the student is not educationally disabled and in need of specialized instruction under the IDEA. The RC case in your materials, it's RC versus York. It is, kind of like that. So the student didn't have an adverse effect because of all of the things that were happening in the home setting. And she had substance abuse. She actually even had a diagnosis of ADD. She also had depression. But even though there were challenges in the home setting, her academic performance, her demeanor, her interactions with others in school were fine. There were no significant behavioral challenges. And so the court found there was no adverse effect. But again, courts are all over the place on this. And so you want to make sure that you are, doing comprehensive evaluation. And because your FAPE is to ensure that students with disability have available to them, special education and related services to prepare them for more than just having great grades, like to be able to, interact with people that they disagree with, to be able to show up to work on time, to be able to, you know, hold down, you know, obtain and hold down a job. Those are things that are may not be academic in nature. So you're looking at, and your IEPs tell you that as well, because your IEPs have not only academic goals, but also functional goals designed to meet their needs. And here's where we're looking at your functional goals, right? The word functional appears on our IEPs. So we know, even just looking at the actual document in front of us, that looking at functional performance is part of educational performance. So what does that mean? What is functional? Well, last time the IDEA was reauthorized, there was a request for the U.S. Department of Education to define that, and the Department of Ed said, no, we're not going to define functional. It's not necessary to create a definition of functional in the regulations. And they said, we believe that that's a term that's generally understood to refer to skills or activities that are not considered academic. So there you go. The definition of functional is, you know, not academics, and used in the context of, you know, routine activities of, you know, everyday living. All right. So now we know what academic performance is. Let's talk about what constitutes adverse effect. And I think that might be on my next slide. So, you know, lots of different opinions out there about adverse effect. What is it? Is it some effect? Or does that effect, that adverse effect, have to be significant? There's some courts and hearing officers say that, you know, a child with satisfactory performance can still have a disability that adversely affects their educational performance because it inhibits performance in some way. It creates a difficulty with performance, or merely because the child's performance could be better, you know, could be improved. Others, again, all over the board, others say that a disability must significantly adversely affect performance to qualify. Now, you know, I'm a lawyer, and so I read laws and things like that. And one of the things that, you know, sometimes when people are trying to interpret what does this mean, sometimes we go back to the legislative history. What is that? That is what was being written about, like in the notes, in the commentary, at the time that the laws were put into effect. That's legislative history. And if you look at the legislative history for the IDEA, Congress was clear about its concern over identification of students. There's actual language in the House of Representatives report that suggests that Congress didn't intend to identify as disabled what they called slow learners. And what they were discussing, who might have learning disabilities. The House report also said that the law is designed to reach those who are significantly handicapped. Okay. When the law was reauthorized in 1997, Congress continued to state its concern about over-identification. And, you know, it's true that this theme continues into the current, you know, to what we currently see. But this debate continues in cases. So I think, you know, this is me, Laura, you know, practicing in this area. I think there's a good argument that adverse effect must be more than just a little tiny, you know, effect. I think it has to be more than minimal, that there needs to be some sort of, you know, some sort of adversity. I mean, let's look at what is the definition of the word adverse. Now, when we get into that conversation, sometimes the dialogue includes, well, what about the student's abilities? Like, if the student has these off the charts abilities, but they're maintaining average performance, does that mean that the disability adversely affects their performance? And, you know, again, courts are all over the place on this. And some people have tried to use the new Supreme Court case, Andrew F., that talks about what constitutes FAPE, meaning that FAPE is what is appropriate given the child's circumstances. Again, I don't think that there's a bright line test here, but you know, I think you are going to need to look at student performance, and you're going to need to take some, you know, have some consultation with, you know, whoever you work with, your legal counsel, your SST or ESC, whoever it is, if there is a debate about whether something adversely affects educational performance. What I've tried to do in your materials is to highlight how there's differences of opinion. And, you know, honestly, when you go to court, the cases are being decided by human beings, and human beings have differences of opinion. There's Mr. and Mrs. I case is one in your materials that I've included. That highlights the the perspective that any negative effect is an adverse effect. And in that case, they are, there's an argument that the lack of a qualifier in that term, like significant or a substantial effect, means that any negative impact on educational performance, no matter how minor, suffices for eligibility. Okay. So, that is the potential. The cases in your materials are there to give you an example of how unpredictable litigation can be. And in the Mr. and Mrs. I case, I will mention one thing. The court looked at um, the fact that in that particular case, the student was ultimately identified as a child who was protected under Section 504. And within the student's 504 plan, the district kind of gave the student related services. I'm pretty sure it was speech therapy. But anyway, they gave related services as part of the 504. And, when looking at this, is a lesson of no good deed goes unpunished, because the court took that as conceding the fact that the student had some sort of need for, a related service, and that maybe that they should have been eligible under IDEA. So I think, I don't know the people who were involved in that particular case. I'm pretty sure it was out of Maine or New Hampshire, somewhere in New England. But, it did come back to bite them in the behind, because the court said, listen, you acknowledged this by identifying them under 504 and providing these types of supports. All right. So and that's really where the intersection of all three legs, because remember, the adverse effect on educational performance has to be directly linked to the need for specialized instruction. So they have an adverse effect on their educational performance such that they require specialized instruction. Okay. All right. What about when you're determining adverse effect? If we've got failing grades, now we're looking at, adverse effect academics. So most people are like, yeah, we get that. What about they're below average, but they're still passing? What about, so you're looking at all of these different factors when you're determining, was there an adverse effect? And you're also looking at all of these factors when you're determining need for specialized instruction. And one of the things that in the adverse effect conversation is, should you consider that either the student is getting extra help, or they're getting assistance from their parent, or they're getting a tutoring or something like that, but for that, they would not be they would have an adverse effect on educational performance. So do you consider that as part of the eligibility determinations? So the Ohio regulations do require school districts to use data from interventions to determine eligibility. So in this case, you're looking at, has there been intervention? And just because they're getting extra help doesn't mean it's specialized. They have a need for specialized instruction. Okay. There's a Montgomery case in your materials that you should look at. So the student in that case had done very well until 5th grade. And then the student began having a whole bunch of issues: lying, stealing, shoplifting. In 6th grade, she was deteriorating even more. She was, wetting her pants. She was requiring diapers. She was having hallucinations. She was hospitalized. She had all kinds of diagnoses, including bipolar and schizophrenia. But when she returned to school, the supports that they gave her were class notes. She had a homework assignment monitoring book. She got extended time. She had adjusted workload, and she wasn't graded on things that she missed. Okay. She also had the ability to just go anytime she wanted to the health room, because she continued to have some hallucinations and needed a safe place to go. So when she was referred for special education, the team found that she had she had average academic achievement. So the team was looking at, does she have a social emotional disorder that adversely affected her educational performance? And they said she did not, because she was, doing well. Well, the family disagreed with that, and they filed suit, and the hearing officer agreed with the parent. The district appealed, and the court, didn't overturn that. The court agreed with the parents again, and the court said, listen, the grades had been adversely affected, or would have been, because if the student had counted all of her missed assignments, if the student had, you know, had she been held accountable for the things that she couldn't do because she was, constantly in the health room, then that would have been an adverse effect. And they suggested that the child's inability to remain in school or in class would be a finding in it would be relevant in finding adverse effect. The court also looked at this need for specialized instruction, and they rejected the district's argument that the student only needed psychological services. They argued that, she only needs this related service and not special education. Instead, the court said, listen, the child actually needs to be in a therapeutic setting, which is, big dollars, for her to have access to educational programming, and that placement would be considered special education. So, just some of these cases have some really good language that you can look at for determining, how you go about having that adverse effect conversation. The Ashley case, in that case, the court found that the child was not eligible, even though they had significant regular education supports. So again, it's the adverse effect creates a need for special education, not a need for regular education. And so that's when, we talked about, can you provide interventions and use the response to interventions as part of your eligibility determination? Absolutely. So in those 60 days when you're doing your assessment and you're doing regular ed interventions, and then you're asking the question, does the child have an adverse effect, right? A disabling condition that adversely affects their educational performance such that they require special ed? No, they don't require special ed, because look at their response to regular ed interventions. Well, then you don't have the third leg of the three-legged stool, which we're going to get into that. So, look at those criteria as they intersect with each other. So let me just see if there's anything else on adverse effect. There's a Toledo case in there, where the court found that adverse effects should be evaluated without consideration of the supports being provided to the student. So in that case, it was help from the parent. That they said, you've got to take into account that had there not been those extra supports, there would be an adverse effect. So again, lots of different. I mean, your handout is very long. So there might, and think about, there might be other causes of an adverse effect on educational performance. There might be other factors that have an impact on a child's performance, but it's the only kids who have an entitlement to an IEP are those students who their adverse effect is caused by a disabling condition. Okay. It could be that there's something like drug use or involvement in criminal activity. Those might have an adverse effect on their educational performance. So that may not be somebody who's eligible for special ed because they're not disabled. Okay. There's an Alvin case from Texas, which is an example where a court considered those outside factors when determining adverse effect. And in that case, a student had been eligible for special ed up until the third grade, but then they were exited because they had a specific learning impairment, and they were exited for services. They did well all the way up into seventh grade, and then the students started having behavior problems. They were, using obscene language, hitting, shooting spitballs in class, I don't know, typical, I guess, seventh grade behavior, maybe. I have a seventh grader. Despite those problems, though, the student passed his courses. He met standards on statewide assessments, but he was having some stuff going on at home. His brother died. He has having a strained relationship with a stepfather, and he is engaging in abuse of alcohol. So in eighth grade, he's placed in an at-risk program. He gets a behavior contract. He has good attendance, but he still has some disruptive behavior. He has a theft. He gets expelled from school, but he's still able to earn passing grades. He still is making, meeting state assessments. But at that point, the parents referred them for special ed, and the team says the student is not eligible. The parents disagreed with that. They go to hearing, and the hearing officer agrees with the parents. The district appeals, and the circuit court agrees with the district. Well, the courts then agree with the district, and they were focusing on, need for special education. They're saying, look, the student doesn't require special education, and they said that any behavioral problems were not because of the student's diagnosis of ADD. They were the result of causes unrelated to the disability, like the death of the student's brother and the student's own alcohol use. Now, I give you that case out there as an example of when the court said all of these things swirling outside of school are not creating the adverse, or is what's having an adverse effect, not a disability. But I will also tell you that many courts, hearing officers, and therapists will sometimes say, well, listen, alcohol use and things like that is oftentimes masking an underlying disability. And so you do have to dig a little bit deeper and ask those questions. So I'd like you guys to meet my colleague, Erin Heydrich. Erin is out of our Cincinnati office. I am going to, so we've talked a little bit about need for specialized instruction and how that intersects with adverse effect. I'm going to run to my IEP meeting, but I just give you an invitation to join us for the rest of the series. And if you have follow-up questions from today, you can, from my talking points that Erin's not able to answer, you can certainly send in questions. And if the SST is not able to answer them, we can certainly do so. So thanks so much for your attention and for all of your great questions. And you are now in good hands with Erin.
Thanks, Laura.
All right.
All right. Kim, just checking. Are we due for a break, or am I just gonna roll through to 11:30?
You can just keep rolling through. We did take a break a little bit ago.
Okay.
And there was, now after I just said there was no questions, one popped up in the chat. Are you able to see the chat, Erin?
I think so.
So the question says, where does lack of appropriate instruction in reading and math come into play in these three areas? And what does lack of instruction look like?
So
how has COVID impacted those?
yeah, I
Do you
can
see that now, Laura.
Yeah, I can answer that question before I have to go.
Thank you.
That is going to be really very fact specific. You're looking at the rule out factor for learning disability. And so those are going to be really fact specific things. The question becomes, if it was lack of instruction and it was your district that failed to provide appropriate instruction, that becomes a really difficult thing to argue about, because, you know, as the requirements for when students were returning from, you know, from COVID, that we were required to develop plans to remediate any deficiencies that were caused by the interruption of services. So I don't think I can give you a one size fits all, but it's certainly the lack of appropriate instruction in reading and math is a rule out for determining eligibility for a specific learning disability. And I would encourage you to talk to your legal counsel about how you navigate that, because the minute that you say that it was lack of appropriate instruction on the school, now you're looking at determining whether or not we failed in another area that we were required to remediate for purposes of student progress.
Just to kind of reorient here, if we think about Laura's three-legged stool, right? First leg is a disabling condition. The second is adverse effect on educational performance. And the third leg of our stool is a need for special education. So disabling condition by itself is not enough. Adverse effect is not enough. We must also determine whether, by virtue of the disabling condition that adversely affects educational performance, there is a need for special education. So for the last part of our time together today, in the last 30 minutes, we're going to talk about what special education is and what it means to need it, right? So the first question that your team may confront is whether a need arises solely because a child may benefit from special education, or versus a need. And so let's take a look at what the IDEA regulations state. And I'm just gonna kind of go through your packet here if you guys want to follow along, take any notes, just to kind of orient you to where I am. I'm in the need for special education section of the packet that Laura gave you. So does a need arise solely because a child may benefit is our question. And the regulations say each state must ensure that FAPE is available to any individual child with a disability who needs special education and related services, even though the child has not failed or been retained in a course and is advancing from grade to grade. So note the word need here. When determining who needs special education, there are often kind of two areas of disagreement. So The first one is, does a child need special education merely because they can benefit from it? And, you know, sometimes we'll see, for instance, like a gifted child with superior cognitive abilities who performs well academically, performs well socially, but maybe isn't maximizing their potential, right? That interpretation of the statute, I would say, conflicts with the plain meaning of the statute or the regulations that we saw, right? The term need is in there. That signifies a necessity, not something that would just be a benefit. And most authorities, you know, hearing officers, courts that we see consider this issue reject that benefit approach and instead consider the child's current performance level to determine whether the child needs special education. Where there are a whole, so that's pretty consistent, but where there are a whole range of opinions and where it gets tough is when we have to determine what level of performance says there is a need. So let's look at some of those opinions. So a student, just broadly speaking, right, a student is going to need special education when they need it to get FAPE, when they need it to make appropriate progress in light of the child's circumstances. And while academic progress is something that we absolutely can and should look at in as an eligibility team, academic progress alone is not determinative. Your teams should draw upon information from a variety of sources, and that kind of goes to the slide that Laura showed you there at the end, in order to make eligibility determinations. So when we look at cases, we see hearing officers and courts consider things like the child's attendance, standardized test scores, mental health issues, social issues. So let's take a look at two example cases in your materials. There's the Monrovia case where an independent hearing officer found that a student required special education to address social, behavioral, and written expression needs, despite the fact that the student was making good academic progress. In the Blazewski case, the hearing officer considered that, again, while the student is passing his subjects, he was achieving low marks in certain basic courses, scored low on certain individualized tests. And although he was in the 11th grade and possessed a high average IQ, he lacked many basic survival skills needed to function in the outside world. So here the hearing officer is focusing on functional performance, not just academics. So the lesson here is when we're deciding whether a child needs special education, don't ignore things like attendance, like motivation, like social skills, like functional performance. Another thing to consider, and Laura touched on this as well at the end, hopefully I'm not repeating too much of what she said, is to consider whether the student is making appropriate progress with regular education interventions. So most authorities agree that educational performance should be evaluated taking into account regular education services that the child is getting. So in other words, a child may not be eligible if their needs are adequately met through regular education supports. So in a district that I was recently advising, we had a preschooler with a mild hearing impairment, and the parent was arguing that the child could benefit from visual supports in the classroom. And there was no doubt that the child probably could benefit from visual supports. I would say most kids, especially preschoolers, benefit from visual supports. And where the team landed was, well, while the child probably will benefit from that, visual supports are provided to all preschoolers. That is our standard method of delivering instruction. That's part of regular education. And so we do not see a need for special education in this particular case. So what is special education? Special education, as you see on your slide there, is specially designed instruction, right, provided at no cost to the parent to meet the unique needs of a child. So in order to understand what special education is, we have to understand what specially designed instruction is. And there's unfortunately no bright line test to say what specially designed instruction is. So we'll talk about some ways of looking at that question. But broadly speaking, specially designed instruction means adapting the content, methodology, or delivery of instruction. So how do we apply that in our team meetings when we are determining whether a student needs special education? So The cases suggest that specially designed instruction is going to mean individualized interventions from the child that are different from what is going to be provided to students in a regular education setting. And we're going to look at some of those cases in a bit. But before I move on from that, I want to talk about, just touch on related services as special education. So we often think of related services as sort of underneath the special education umbrella, as something that allows kids to access their special education. In certain circumstances, related services themselves can be considered special education. And again, you can drive a truck through this definition, but it's just important to know. So the IDEA says related services are special education if the state says they are. So what does Ohio say? Ohio says related services are special education if the IEP team says they are. So you, as you are sitting on IEP teams, may have to make this determination about whether the related services are special education. And this is especially important if the child is only getting, if you think, well, the child really only has a need for related services. So related services are provided to eligible students if the services are necessary for the child to benefit from their special education. Generally, if a child only needs a related service, and if that related service is not considered to be special education by the IEP team, then the child is not going to be eligible. So IEP teams take various approaches to determining whether a related service is special education. Some teams say that there must be an adaptation of the content, methodology, or delivery of the instruction in order for it to be special education, which is the regulatory definition, right? It's hard to argue with that. Some teams say if we're making any adaptation to the child's education that we would not do for a regular ed student, that's special education. That's a very broad approach. Some teams say it's not just any modification, it's a significant modification that we need in order to consider it special education. Other teams just ignore that element altogether, and I see that a lot. And this can create some problems down the line. So there's a case in your materials that Laura may have discussed with you earlier, the ELIDA case, and if not, you can reference it in your materials. But there we saw a court look at, does the child have a disabling condition? Does the child have adverse effect on educational performance? And the court said yes to both. Great, we're done. Kid is eligible. School district, you messed up. And so it appeared that the court, like we see a lot of people do, merely presumed that the child was eligible because they had a disabling condition and because they showed adverse effect on educational performance. So a couple lessons from this. One, unpredictable results happen when cases get litigated, and so that's why we try to avoid it. And two, when you're discussing with your eligibility teams, you don't want to ignore the question of whether a child needs special education. And you don't want to ignore the question of what specifically you, the team, are considering to be special education. Make sure you are answering those questions in your IEP. Make sure you are answering those questions in your prior written notice, so that if the worst happens and we have to march into a due process hearing or a court someday and hand over these documents, we can remind our hearing officer or our judge, look, there's also this third leg of the stool, and look at what the team decided on this. And so just lessons from case law, always useful. All right, so let's talk about adaptation of instructional methods as special ed. So there's an argument that accommodations that allow the child to access instruction and demonstrate learning, so things like extended time, preferential seating, organization tools, note-taking, are not modification of the content, methodology, or delivery of instruction. But there are different opinions on this, and so we'll talk about that. Some authorities say these kinds of modifications are special education. Some authorities say these kinds of modifications are accommodations and are not special education. So generally speaking, Modifications in teaching methods that are minor, that are available to all students are probably not special education. So like chunking tasks, providing written instructions, monitoring student attention, monitoring student behavior, monitoring homework completion, communicating with the parent, visual cues. Those are the kinds of things that if you've got a good teacher, they are doing those things, right? And those are part of the regular education program. Those are not special education, although they often show up on IEPs. Those by themselves probably are not sufficient if a student only needs those to say that they need special education. But authorities are split on this, and you'll notice that we're going to talk about some cases, and you're going to notice that they are all over the place, which makes it harder for you to do your jobs and harder for me to do my jobs, because I can tell you that in some of these cases we're going to look at, if this IEP team had called me and asked me, I would have given a different opinion than what the court said. So we'll talk about that. So in this Howard County case, an administrative law judge said that the modifications the district provided to a student were not special education, and the modifications included corrective reading instruction, adjusted spelling lists, a unique reading and spelling program, math support, and other classroom modifications, including a speller, visual cues, and preferential seating. And I'll tell you, if an IEP team had called me and said, or an eligibility team had called me and said, well, we think the kid needs special reading instruction, we think the kid needs adjusted curriculum, we think the kid needs, unique programming, I would have said that's special education. But here the judge said, no, that's not special education. And so that kind of highlights the unpredictability of some of these cases. In the South Hadley case, again, court said not eligible for special ed because the supports that the kid was getting were visual aids, graphic organizers, socialization, reinforcement, and modeling, and a friendship group. I really do not know how you provide a kid a friendship group as like a service, but hats off to them if they were able to do that. But I'd say that probably makes sense. I would probably agree that visual aids, graphic organizers, social, like minor social supports are probably not special ed. We look at the Fayetteville case. Here, the court said the following was not special ed. So group social skills programs, speech improvement services, counseling, remedial reading, remedial math. Those were not special ed. So, I'd want to know more about what the remedial reading and remedial math are. Maybe those are part of a general ed program at that school. But again, if that team had called me and said, well, we think this kiddo needs speech improvement, we think they need a social skills program, we think they need counseling, I would have probably said that's probably special education. But here the court said no. All right, in the Brado case, the court found that home instruction itself can be a form of special education, and Laura may have touched on this. So in this particular case, the medical testimony suggested that this child did not actually need home instruction, but it's an important reminder that if you have a student who is not previously identified who is asking for home instruction, that might, I'm not saying they absolutely qualify for an IEP, but that might set off an alarm bell in your head of like, okay, let's be attentive to this kid's needs. Have we missed anything? Do we need to evaluate for anything? It's just important to keep in mind. Skipping down to the Chelsea case, here the court said there is no bright line test to determine whether specially designed instruction is required. So I guess it's helpful if they acknowledge that, but it's not really very helpful in practice to not have a bright line test. But the court observed here that the student's low grades in math were primarily from the student's failure to complete her homework, and her test scores indicated that she was achieving in the general ed curriculum without special education. So again, this one, I would tread lightly before concluding. I see, I'm dealing right now with a situation in a district where they're saying, well, it's not, the kid is, he's not doing his homework, he's not showing up for school. So, we just don't think that's our responsibility to like respond to that. And it might be that this is not the result of any disability, you know, I don't know. But I always get a little prickly when I see that, you know, we do have a responsibility to address behaviors that are interfering with a student's learning. And behaviors are not just things that result in discipline. It can be things like not showing up for school, not able to complete homework, not showing motivation. Those should be triggers for us to say, okay, is there something going on here that we need to look more closely at? So while this case exists, I'm not going to deny it. I will just, I will caution you against relying too heavily on saying, well, it's really not the kid's disability, it's that they're just not motivated, they're not doing their homework. You know, that might be something that we do have responsibility to look at. Okay, and then finally in this Pittsburgh case, here the court held that a 5th grade student with a history of impulsive and non-compliant behaviors who was making progress after receiving general education interventions was not eligible because the interventions she was getting, which were a highly structured setting and provision of a one-to-one aid, did not qualify as special education. Again, I'm telling you, if a district had called me and said, well, we think this kid needs a one-to-one aid and highly structured setting, I would probably say that's special education. But you know, here the court said no. So where courts are going to draw the line in determining what modifications rise to the level of special education is really difficult to predict. I think if we're going to try to come up with a rule, I think key elements include whether the modifications are available to all students and whether they represent expectations that regular education supports will include modifications and accommodations. So like minor modifications to content, method, delivery, that should really be encouraged in regular education classrooms and not reserved exclusively to the special ed world. So I think good teaching requires those kinds of adjustments. And children are often referred to special ed because they can't get those kinds of adjustments. So maybe they just need extra support rather than special education, but they aren't getting it in the classroom. And so if special education is the only place where they feel they can go to get those kinds of supports, it's no wonder that eligibility is so attractive and we have so many conflicts about eligibility. And I know that is much easier said than done. I was a classroom teacher for 5 years before I was a lawyer, and I'm not too proud to say I wasn't a very good one. So I know these things are very, very hard to do. But I think the more we can encourage modifications in the regular ed class, in the regular ed program, the easier it will be to respond to these eligibility questions. So, okay, I have some information here about, and Kim, I'll ask you about specific learning disability. And did Laura already cover this? Do you know? No, I'm seeing some heads shaking no. Okay, so I know that we're running out of time, so I'm going to go over this. I'll go over this quickly, but of course we can answer any questions that you have after. And I think we need to probably jump ahead a couple slides. Sorry. There we go. Oh, one back. Okay. So when we are evaluating for specific learning disability, few key things. So one, remember that, I think Laura may have covered this, there are additional team members that need to be involved. So again, consult your packet for which team members need to be involved in that. And then there are special ways to determine eligibility. So federal law states you have to determine how your state is going to determine eligibility. And so Ohio gives some options. So Ohio says you can, but are not required to use a severe discrepancy model, which is determining whether a child has a severe discrepancy between intellectual ability or IQ and their actual achievement. Ohio says you can, but are not required to use a response to intervention model. So comparing how the child is responding to interventions with their potential, with where we would expect them to be. And then Ohio says you can, but are not required to use alternative methods of determining whether a child has a specific learning disability, as long as they are research-based and evidence-based. So Laura may have touched on, in July, Ohio's operating standards were amended. And the amendments were pretty minor, to be honest, but one thing they did change was they created a definition for evidence-based intervention, and then they added to the specific learning disability procedures, the phrase evidence-based was added multiple times, right? And so it's clear that the Department of Education or Department of Education and Workforce is really wanting our teams to focus on evidence-based interventions. And that definition is included in the materials that Laura gave you. So you may want to like circle it, star it, highlight it, because that's a definition you're going to want to consult when you are determining whether a student has a specific learning disability. Just being cognizant of time. So when we are documenting our evaluation, so the operating standards say that when we are using a response to intervention model for evaluating for SLD, we have to include certain things. So there is a list, and that is included in your materials, and I'll kind of touch on what the items are in that list. But we need to show that evidence of an inadequate response to intervention. That makes sense if we're using a response to intervention model. We want to show that the interventions we used were evidence-based. So there's that word evidence-based again. That's why it's really important to like circle, highlight, star that definition. We want to show that the assessments we used were evidence-based. So again, really hitting home the evidence-based. And we want to analyze the data to show a discrepancy between actual and expected performance, which makes sense because that is what a learning disability is. And like always, we'll need to show that we are not using interventions to unnecessarily delay an evaluation. So all of that should be documented in your evaluation team report if you are using that method of determining eligibility for a specific learning disability. And again, that list is included in your materials, so you can refer back to it if that comes up. So there are 3 ways to be found eligible for a specific learning disability. And then there are, and if a student meets any one of those 3, then they are eligible. They do not need to meet all 3. And then there are some carve-outs that apply to all of those methods. So a student can be found eligible if they are not achieving adequately for their age or grade level, if they are not responding as appropriate for their age and grade level to interventions, or if they exhibit a pattern of strengths and weaknesses in performance, achievement, or both that causes the team to suspect a specific learning disability. So if a child meets any one of those 3, they would be eligible unless one of these carve-outs apply. So the team must also look at whether the child is having these learning difficulties primarily as a result of a visual, hearing, or motor disability, intellectual disability, emotional disturbance, cultural factors, environmental or economic disadvantage, or limited English proficiency. So if the team determines that one of those things is causing the learning disability, then the child would not be eligible. And again, this is all outlined in your packet. I'm going through it quickly because I am just trying to be cognizant of time. All right, just to highlight for you the PRO6 form, section 3 of that form, it walks you through what you need to document if you are considering specific learning disability. So certainly consult that form because that will help. And when you are evaluating for specific learning disability, each member of the team must certify in writing whether the report reflects their conclusion, and they're so signing the signature page, right? If it does not reflect a particular team member's conclusion, then that member must submit a separate statement explaining how they disagree with the conclusion and what their conclusion would have been. So those are just some differences between doing SLD evaluations and other types of evaluations. So in our last few minutes, we have a little scenario. If you want to move ahead to the next slide, there you go. So I'll read this scenario to you. So Jenny Smith is an 8th grade student with severe and potentially fatal allergy to peanuts. She's been identified as a student with a disability under Section 504, and your district is addressing her allergy-related needs through a 504 plan. Jenny's not very popular. She has a hard time interacting appropriately with her peers. She often interprets normal interactions as threatening or mocking. Because of this, her teachers have reported that she struggles to concentrate in class as she fixates on perceived slights and sometimes lashes out at her peers. She's received a handful of detentions, 4 days of in-school suspension and 8 days of out-of-school suspension this year because of her behavior. One of the suspensions resulted after Jenny lashed out and struck a classmate following a report he gave on the benefits of George Washington Carver's work on peanut cultivation. Jenny was suspended for 5 days for her behavior and refused to return to school for a week because she did not feel comfortable. Last week, one of Jenny's classmates, Nick, who just moved to the district, brought a bag of peanut butter cups to school to share with his friends. Jenny became very upset and ran out of the classroom to the office. While there, she told you that Nick brought the candy to school specifically to harm her. She then asked to contact her mother so she could go home. Since that time, Jenny has not attended school. This morning, you received a distraught call from Nick's mother about a post Jenny made on Facebook. The post read, "I know you tried to kill me. You know what happens now? Death." Nick's mom believes that the post constitutes a threat against Nick, and she is demanding that Jenny be suspended. You agree. When you call Jenny's parents to inform them of the intended discipline, they say that Jenny's fear in reaction to the peanut butter cups has caused her to have suicidal thoughts. They explain that the post was not made as a threat against Nick, but reflecting her own desire to die. They report that Jenny has been working with a psychiatrist and is suffering from PTSD from her multiple trips to the ER and because of the George Washington Carver lesson last fall. Jenny's parents believe that the district cannot ensure her safety and say that she will not return to school. However, they still want Jenny to be able to receive the same education as her peers, and they ask that the district provide Jenny with the option of participating in lessons virtually. When you offer participation through a phone conference or webcam, Jenny's mom informs you that she learned about a robot that could go from class to class for Jenny, allowing her to view instruction live, ask teachers questions, and participate in discussions. They want the district to provide this robot so that she can access her education from home, which she considers safe. All right, so in our last couple minutes, let's touch on some of the issues that we might spot here. So since this is a child find presentation here, let's talk about child find. I think the issues that I would be concerned about here is whether we've identified all of Jenny's disabilities, right? I think that there is some evidence that she may be experiencing emotional disturbance. And I know Laura went over this with you. So that can include things like inappropriate types of behavior or feelings under normal circumstances, a tendency to develop physical symptoms or fears associated with personal or school problems. I think we saw those things in this scenario. And then another thing that we see get missed a lot is we've got this disciplinary stuff going on with Jenny, right? So how do we handle that? Important to remember that she has a 504 plan, so she's going to get certain protections in the disciplinary process, but that 504 plan only refers to her peanut allergy. So we probably wouldn't say that her actions are a manifestation of her peanut allergy. But we might say that they are a manifestation of her suspected emotional disturbance, right? We haven't identified her as such, but the obligation to give those disciplinary protections applies if the district is deemed to have known the child was a student with a disability before the incident occurred. So it's important to remember to factor in the disabilities that we may be considering or that we maybe knew about or should have known about in that manifestation process, even if she hasn't been identified yet. In terms of the request for the robot, right, we want to remember our FAPE standard. So under 504, that means receiving educational services as effective as those made available to non-disabled peers. And under the IDEA, it means an IEP reasonably calculated to ensure that the child makes appropriate progress in light of their circumstances. I think I would probably say in this case, I don't know that the robot is necessary to do that, right? The district offered virtual instruction, and I would say that probably would meet the standard under 504 or IDEA, depending on whether we find her eligible for that. Remember, we're not necessarily required to give the best possible specially designed instruction or special education, but it needs to be reasonably calculated to allow the child to make appropriate progress in light of their circumstances. So, okay. I know I'm over time, but I'm going to read real quick a poem that Laura wrote because it is fun. All right. To be or not to be, that is the question of eligibility. To Shakespeare, I offer my apology for this attempted special ed soliloquy. The question of a student's disability is answered by completing an MFE, which determines the need for an IEP and the student's entitlement to FAPE. It starts with something called Child Find, then a plan for assessment is designed. You ask for consent and hope it's not declined. Then 60 days later, the evaluators opined. If it's a language deficit or a deficiency of mind, a child with autism or one who is deaf or blind, emotionally disturbed or wheelchair confined, or learning disabled and now falling behind. Disabling condition and adverse effect, need for specialized instruction in any subject. Which category does the team suspect after considering the data it took time to collect? The decision is made, does everyone agree? If not, will the parent want an IEE to find out if he's a child with a disability who is entitled to receive an FAPE? So when you ask to be or not to be, or question a student's eligibility, I hope you will remember this bit of levity from wannabe poet, Laura Anthony.